Hi, everyone. Welcome to Unit 4. This is our second part of discussing communications in the law office. And this time we're going to focus a little bit more on the message. As you can see by the breakdown in this chapter, we're first going to discuss oral communications, that is, us talking to each other, but we will also spend some time on written communications, more specifically on the concept of writing letters in the law office. As you know from Unit 3, we spent a little bit of time talking about the technology aspects of email, but we also will focus in this unit a little bit more on letter writing itself, but we'll also have a chance to also talk about writing letters through email as well. All right, so let's get right down to it. So the first couple of things I want to talk about are just some general principles to communicating in the law office. Again, we talked about the phone, we talked about email, but now let's focus a little bit more on the who, what, and where. So who are you communicating with in the law office? Well, a lot of different entities. Obviously we're communicating with our attorneys in the law office itself. So we're going to focus on communications with people that are not actually employed in our law office. So with whom do we communicate? Well, often we communicate with our clients. In fact, very often the paralegal is the go-to person for the client to call. And this is for more than one reason. Number one, your time, your billable time that we've already started to talk about is actually less than that of the attorneys. So it is actually less expensive for the client to call you and speak to you about updates in the case and what's happening than with the attorney herself. So that's part of the reason. The other reason, truthfully, is that very often the paralegal is even that much more connected to what is happening with the client's case, what's coming up on the calendar or docket, what documents are due, what type of meetings need to be held in order to move forward to the next stage of the case. So when you want it, there is an awful lot of client contact. So that is somebody with whom you will be speaking and communicating with in the law office. You'll also have an opportunity to speak with potentially opposing counsel, and we'll talk about opposing clients in just a minute. But of course, the other big category of people with whom you'll be communicating would be the courts, third parties such as insurance companies or banks, and then of course, any other third party witness or vendor. So there's a whole bunch of people that you can speak to. But I wanted to point out two really critical points about any time you get on the phone with any entity when you're at your law firm, or if you're having an in-person meeting. One of the important ethical rules has to do with representation by counsel. If another party to a case, let's say you're representing the plaintiff and there's a defendant in the lawsuit, or vice versa, you're representing the defendant and of course there's a plaintiff in the lawsuit. If that other entity, that other party, is represented by an attorney, then you cannot speak with that party directly. There's an important ethical rule that says if some other entity is represented by counsel, then we need to speak to that attorney. So even if the opposing party calls you up and says, hey, paralegal, I know we have a deadline coming up. My own attorney hasn't told me the deadline. Can you tell it to me? You should answer that they should speak to their own attorney because they are represented by counsel, and the rules of professional conduct prevent you from speaking directly to a party who is represented by counsel. So that includes over the phone or in-person meetings. The other big caveat I wanted to point out is not just the who we speak to, but where we speak to people. Obviously, we conduct a lot of business over the telephone, and that's true during a time of COVID, and that's true even during non-COVID time. We conduct a lot of interactions with our clients and with others over the telephone. So this brings us back to one of the issues we raised in our last unit, which is the concern over confidentiality. If you are having a telephone conversation and you're walking down the road, or you're using your headset and you're in the grocery store, other people can hear what you're saying. And so you risk client confidences if you're having conversations in the open public. You'll see when you visit a physical law office that there's an awful lot of offices that have the ability to close a door. And that's not just to be kind of like standoffish, like, oh, don't talk to me. It's because we need to maintain that client confidentiality. So when a client comes into the office, if she's waiting in a waiting area or a common area, this is not a place to have a conversation where client confidences can be revealed. Wait till the client visits a private office or a conference room where you can shut the door and you don't have to worry about privacy concerns. I specifically chose this clip art here because it looks like these individuals are having a conversation at a restaurant. You might find that there's not an often time where clients and attorneys and paralegals are meeting in public places, and that is for a very good reason. It's because of the client confidences. Okay, so just a few other nuts and bolts in terms of your role as a paralegal and communications in the law office. It's really helpful anytime you're working with a client or a third party or opposing counsel to introduce yourself and state what your role is. State that you're the paralegal. That way you don't fall into this trap that I mentioned on this slide too about the what we call the unauthorized practice of law. It's a fancy way of saying that the ethical rules clearly divide what tasks can and cannot be done by an attorney, and then what can and cannot be done by everybody else that might work in a law office, including a paralegal. And we need to make sure that the client knows that you're the paralegal. So hopefully that means the client is not asking you for your legal advice or attorney, or your legal advice or counsel, because that is for the role of the attorney. So just by introducing yourself and stating what your role is, we can avoid a lot of confusion up front. Now, I'm not suggesting this is you or this is going to be your lawyer one day, but do take a look at the really horrific case on page 97 in your book where an attorney was committing unethical practices by basically giving all of his legal work to paralegals and having them act as attorneys. That is a big no-no. Don't do that. The lawyer will face ethical issues, including disbarment. But just so we know, keep those roles separate. Make sure you introduce yourself to clients and to others as the paralegal working on the case. Okay, now that we've got some nuts and bolts out of the way, let's start talking with oral communications. So I didn't write oral communications here because I wanted you to just see these words. Prepare, prepare, prepare. Most of us, including me, cannot walk into a meeting, an in-person meeting, or pick up the telephone and have a telephone conversation on the fly. I don't know, I'm sure there are some people that can, I just don't know them. The best thing that you can do to prepare for an in-person meeting or a telephone call is to prepare ahead of time. Because once we are in the meeting, it is very difficult, if not impossible, to talk with the people that you're meeting with. Again, this is a picture, either the phone or in person or a Zoom. So you have to talk to individuals, you have to listen to individuals, and you have to be able to think all at the same time. And that takes a lot of skill and is almost impossible to do. So your book sets up a pretty good checklist of the prepare, 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 but I just want to go over some of it with you so we can emphasize exactly what we mean by be prepared before you pick up the phone. And again, whatever method works for you, if you like an old-fashioned notepad, in fact, I will show you my notepad. I buy these at Staples all the time. They're just these little notebooks. And I literally keep all of my day-to-day notes in here. It's not a great system. I don't file anything, but I'm an old-fashioned pen and paper person. So right before I have to, even teach a class live or make a recording like this, I tend to write down a lot of notes for myself ahead of time. So you could do it on paper, you can do it on the computer, whatever system works for you. But here are the things to focus on. Number one, ahead of any meeting, keep in mind what is the goal or purpose of that meeting. For example, you might be meeting a client for the first time. And so the goal of the meeting is to learn about the client's case, learn a little bit about the client himself or the business he operates or what happened to him, and establish a rapport and set up the attorney-client relationship with the attorney. Perhaps that's the goal of the particular meeting. So always have that in mind so you don't go down a path that you're not meant to, kind of keep yourself on track. What about location setup? This is a really important role for a paralegal. And this is true whether you're meeting in person or you're meeting over Zoom. When your client comes to the office, or someone else, let's say a witness that you want to interview, comes to the office, or perhaps you're setting up a virtual Zoom meeting with your client or again, a witness or somebody else, their time is valuable, just like yours is. Imagine if you had a client show up to the office and the conference room was a mess because the person using it before left empty coffee cups there and papers all over. And now you have to ask the client to wait in the waiting room while you get it ready. That's not great. Take those 5 minutes before to get the conference room ready, make sure the temperature is comfortable, make sure there's drinks or snacks or anything there that needs to be done. And the same thing can be true with a Zoom meeting. If there's any information, or let's say you need to share documents with a client virtually or electronically, have those documents ready to share electronically so that you're not stopping in the middle of a meeting and then having to go find them and come back. So you can see it's really all about being efficient with your preparation so that you can be respectful of this person's time as well. Nobody likes their time being wasted. The next step in terms of preparation is a little phrase I stole directly from your book, Who Stole It Directly from Aristotle, because I think this actually makes a lot of sense. Ethos, pathos, and logos. So think about the client coming in who is nervous, has maybe never met a lawyer before, or even if the client has met and worked with lawyers before, this is a particularly daunting legal task or legal matter that's weighing very heavily on the emotions of the client. So your client could be, a little old grandmother, or it could be the CEO of a company, but it might be her company and she's very nervous about the lawsuit. So put yourself in that client's shoes of walking into that door and bring with you these principles. Number one, ethos, establish credibility, right? You are there to welcome them and to say, who you are and what you're there to do and what are we going to accomplish today. Pathos goes to the emotional connection. Now, we don't want to cry with our clients. We don't want to get emotional, but we want to make sure that they understand that we feel the emotions that they have also. You're not just sitting there robotically taking notes, because then they might as well talk to a computer. You're a real person also. And lastly, the logos. That's the idea of using reasoning and putting together what the client is there for with the legal work that needs to be done. That's part of our jobs also. Okay. Next on the list is be prepared to take notes. Again, maybe your preferred method of taking notes is on the computer and you like to type notes. Maybe you prefer to handwrite them. But this is something critically important to do when we are meeting with clients, witnesses, and so forth, or whoever we need to speak to. It's possible that you could record those meetings, but the truth is, even if you record the meeting, you're just going to have to listen back to it later and take those notes. So this is a good skill to practice, is your listening skills while someone is talking and your ability to jot down and take notes of what that person is saying. That is not easy to do, because remember, at the same time, you're already thinking about your follow-up questions and you're already thinking about other matters you need to get to, and you need to respond substantively to what this person has told you, because you need to think, okay, well, they're giving me some information. Maybe there's new questions that I have based on what they're asking me. So even while you're in this class, even listening to these videos, see how you are about taking notes and writing down all the important things that I say without the ability to pause and rewind and ask me what I just said. That is not easy to do. And it definitely takes skill to do that. So again, here I am at 14 and a half minutes. So I will stop here and end video number 1, and I will finish this section on video number 2.